All right, everyone. We're going to go ahead and get started with the mock hearing presentation now. Before we do that, I want to introduce Judge Eliza Klein. She's a retired United States immigration judge who sat on the bench in Miami, Boston, Chicago from 1994 to 2015. Prior to being appointed to the bench, she practiced in Boston, concentrating on immigration and criminal law. Eliza received her JD from Northeastern University School of Law in Boston and her BA from Kirkland College. She's returned to private practice and limits her work to immigration matters now, and we're very grateful to have her here today.
Thank you.
With that said, we're going to do a mock hearing, as Helen talked about already. And the idea with this whole hearing is to try and capture as many aspects as possible that an attorney might be able to convey at the earliest possible stages of the proceedings. And what we want to really do is give you some ideas and some tactics for how to continuously hold the government, both EOIR and DHS, to their burdens and responsibilities that they do have in immigration court. All too often, we end up kind of going through the rote procedures that we're so used to, that we were taught to do years ago, conceding certain things, admitting the allegations, concede the charge, and move into relief and start with kind of the meat of it there. But there's a lot, as Helen just mentioned, that can be done before there that to protect your client's interests. And in the current climate, things that are probably going to have to be done in order to protect your client's interests, because they might be the only chance you have. So with that, we're going to go through this. We are going to kind of stop in between each kind of distinct section of this and try to do a quick Q&A as to why maybe we said this or why it was done this way, because we want this to be kind of interactive so that you can get some ideas for how to go about it if you were in immigration court.
Well, we're back on the record. I've already stated the name and the A number of this child, along with the date and location where we're sitting. So to counsel, please state your appearance for the record.
Helen Lawrence, appearing for the respondent, Juana Mendoza, who's present in court, 13 years old.
Brandon Roché, ROCHE, for the government.
So I'm going to skip my usual questioning about the child and go straight to service of the notice to appear. So counsel, do you acknowledge proper service of the notice to appear dated January 12, 2015, and waive a formal reading on the record of those charges?
No, Your Honor, we do not concede proper service. The notice to appear in this case was not properly served. I ask that the government prove proper service.
Well, what are you claiming went wrong here, counsel? I see you have the NTA in your hand. The docket is very crowded. As you look around behind you, a lot of people are waiting for their hearings. Let's move on.
Respectfully, we stick to our objection.
Mr. Roché, what's the government's response?
Respondent clearly received notice of the removal proceedings against her because she's here in court today. Under VA precedent, actual notice will always suffice.
Your Honor, proper service is required by statute, regulation, and case law. DHS must comply with the NTA service requirements applicable to children, particularly those under 14 years of age, under 8 CFR 103.8 C2 Roman numeral 2 and matter of Amaya. There are 3 independent reasons NTA service was not proper. First, the certificate of service on the NTA lacks the child's signature, even though the service was supposedly done in person and the child was in OR custody. Second, DHS knew that her mother was in the United States and never served the NTA on the child's mother, as required by Mejia Andino, matter of Mejia Andino. Third, she was ultimately released to an adult sponsor, so DHS had an obligation to serve the NTA on the known adult, but DHS never did so. Today, the government argues that service was proper because the respondent is here in court. That argument should be rejected. Respondent's presence here in court does not demonstrate that the NTA was properly served. It merely demonstrates that she received the notice of the hearing as to the date, the time and place of her removal proceedings. The proper remedy is termination under 8 CFR section 103.8 and matter of Mejia Andino.
Your Honor, I have extra copies of the NTA right here. Let the record reflect that I'm serving the child in open court and there's no prejudice.
Your Honor, service of the NTA in open court does not perfect service for 2 independent reasons. First, the regulation requires that DHS serve the NTA properly before filing the NTA with court. It's too late to do it today. Secondly, it would violate fundamental fairness to make it futile to object to improper NTA service by allowing the government to serve the NTA at the hearing where the child challenges improper service. If service is flawed, the court should terminate proceedings.
Not true, Your Honor. Under the newly issued matter of WAFC, a continuance should be granted for that purpose. The decision held that continuances should be granted for the department to seek to reserve the respondent under 14 and effectuate proper service of the NTA.
Your Honor, I'd like to note for the record that there's currently a motion to reconsider and an amicus brief pending before the BAA in matter of WAFC.
Motion to reconsider doesn't matter, Your Honor. It's a VA precedent decision.
So, counsel, I'm going to grant a short continuance for the government to effectuate proper service. Let's set a date 1 month from now for the parties to meet again, and I expect respondent to be ready to take pleadings at that time.
Your Honor, I think it would also be helpful if the government produced the Form I-770 for the court and respondent, so that since that is also one of our bases for termination, is the failure to comply with the regulations mandating I-770.
Well, I've heard rumors of this Form I-770, but I don't know what it is. It's nothing to do with the way this court functions. Can't you just file a FOIA and obtain it that way?
Your Honor, we actually have already filed our FOIAs, but in practice they often take 3 to 6 months to receive the results, and the results are often redacted and incomplete. In the spirit of judicial economy, I think it would be fastest if the government would provide a copy to the court.
Fine. Mr. Roché, please also produce a copy of the Form 770 by the next hearing. So,
Yes,
yeah, so we're off the record. Continuance is granted. Time out. Yeah. There's a couple things. I think, if we see these cases moving more quickly, more procedural errors, I think attorneys should really think about arguing in their cases, even their strong cases, that the court and the government stick to each requirement, which is establishing proper service of the NTA, also reading the factual allegations and the charges and explaining those. And it's not such a bad thing, because when the dockets are crowded, if you slow things down, fewer mistakes are made, but when they are made, you can use those later, potentially. And judges are under a lot of pressure, and they do sometimes make mistakes. My view is that you should really stick to your guns on the procedural requirements. And I was going to say this later in my talk, but one of the things I noticed frequently was that the notice to appear that I had was sometimes not the same document that had been given to respondent. And in that case, we do need to terminate the proceedings. Because frequently what happens is, as the cases are being rammed through the system, the officers who are issuing and serving the NTA may not be the officers who are authorized to sign them. So that signature gets added later after it's served, but before it's filed with the court. And I have had it happen where the actual charges are different, the factual allegations are different. So you've really got to make sure that what you have in your hand is the same thing that the government has given to respondent. And I've actually had it happen where I had the only copy. The government had given me something that they no longer had in their file. So, I had to make copies for everybody of what had actually been lodged with the court. And if I hadn't been very particular about the number of factual allegations, the charges, and the date on the NTA, nobody would have known. We were all talking about something totally different. Okay, so make sure that the NTA is the same date. Make sure that it's read on the record, the factual allegations and the charges. Depending on what they are, you might not want that in open court. If there's anything sensitive, you might ask for a short, individual hearing.
I think, again, it goes to, getting a copy of the NTA that the court, getting a copy of what the court actually has, and you can just go, in my experience, you can just ask the court, you're reviewing a file, or just a request for the NTA, and that NTA that the court has is different. It's always different than the ones your kid has, in the sense that it's got a stamp on it. And that,
right. Well, the best practice is to go and review the file before the hearing. But if you aren't able to do that for some reason, you can ask to approach the bench and make sure that, and compare them to make sure they're the same. There are other ways around it besides a full reading.
I know in the Houston Immigration Court, it was taking a couple weeks minimum to review the case files. Does anyone know what the timeline is right now? A month and a half right now?
No, no. Don't make any assumptions. You know, I mean, I've had attorneys come in and actually file pleadings and say, I'm admitting these 4 factual allegations, and I'm conceding the 2 grounds of removability. And I say, well, counsel, there are 6 allegations and 3 grounds of removability. So you can't make these assumptions. You know, it isn't every time that it happens, but the more cases are rushed, the more these things do happen. Right. So, there are...
Just to paraphrase for the record, the El Paso judge is very nice and patient, and should we be asking them to read every NTA into the record?
Right. I mean, I really think different strategies work for different people, and I also think different strategies work for different cases, and so you do have to do an assessment. But my concern, and I'll get to this when I'm sort of talking about what my frustrations were as an immigration judge, is that everybody makes assumptions. The system is sort of geared up to move very, very fast. The dockets are packed, and mistakes get made, and nobody ever figures it out. And people are deported every day that should not be deported. And, I just feel very strongly that as advocates for especially these vulnerable children, we should do everything we can to slow down. The courts don't have the standard of the best interest of the child, and different judges interpret their rule differently, so you have to know your judge. Some judges are extremely careful with the NTAs, but not all are. If you frustrate the judge can start ruling against you on things that the judge might otherwise have granted, but it's unlikely the judge will make a substantive finding that's different, or a discretionary finding that's different. They might deny a lengthier continuance in other cases or something like that. But, you have to know your judge.
So did everything?
Well,
Again, to paraphrase, how would you advise that we deal with a more hostile judge?
Right. I mean, I think the thing is to be the mature person in the room. If there's not anybody else who's a mature person in the room. I mean, one thing I've learned, I've been practicing immigration law for over 30 years. The laws have changed. The procedures have changed. The legal standards have changed. The definition of crime, conviction have changed. The definition of child is up in the air. So I think the thing to do is to say to the judge, we do not waive a reading because we believe it's very important for the record to reflect what exactly the charges are, what exactly the facts are. I'm not saying I'm unwilling to read to those on the record, but I am saying that I want it to be clear on the record what he's being charged with. And additionally, to have another person explain this to my client who's a child who can use additional explanation. And it depends on how strongly you feel about it. If you're going to cave because the judge is impatient, I wouldn't do it, because then I think, it's not an effective strategy.
My colleague, Helen Lawrence, had to go over do an IJ review of a negative credible fear finding this morning, which the judge in San Antonio did, and he said he started yelling at her off the bat today, and was extraordinarily hostile. He would try to interject with a few pieces of advocacy and he shot her down, but he vacated the decision. So
And
sometimes you have to.
I mean, the CFI is different because there isn't a right to counsel. So the judge really has the right to determine what's the scope. And, maybe the judge was going to vacate anyway if it's just going to be, they might have 4 other cases that they've got to get done before long. Who knows? I think you should not go into court anticipating that the judge is going to screen or rule unfavorably because you're sticking to their burden. That's their job. That's their job. They can't determine whether it should or shouldn't happen. You're the attorney, and you can waive it, but you're not obligated to waive it. And I think that as cases go out further, these cases could get backlogged for many years. Later on, if the person doesn't show up for a hearing, they could say, my attorney never advised me. And you don't have anything on the record, if the judge advised that person. So maybe your client is better off if you've never given them the advisals of the consequences of a failure to appear, and if it hasn't been on the record. But, the judge's bench book says this is what you're required to do, and judges skip steps all the time. The steps have been skipped when your child was in custody and they were taking a statement and they used an older person to interpret. Those steps have been skipped, and finally something really goes wrong. So I think, the reason to have a lawyer is to prevent those things from going on. But if, your judge is overall a fair judge but impatient, doesn't want to waste their time on one thing but is likely to grant relief and you've got a really compelling case, you might say, Judge, in this case I've explained the charges, the factual allegations we're admitting, and I'm conceding and I'm waiving a formal reading. You might want to do that. I don't think there's one strategy that's right for every attorney or every case or every judge.
Yeah. So does everyone understand what happened in that first hearing? So I challenged proper service. The government brought up WASD, and then the judge granted it.
So we're back on the record here in downtown Houston Immigration Court. I've already stated the name and A number of this child along with the date. The parties have already stated their appearance for the record. Counsel, has your issue with the service of the NTA been rectified since the last hearing?
Your Honor, we have evidence that the child's parent was properly served and the child is here in court again today.
Okay, so we're moving forward. Counsel, are you prepared to plead? Your Honor, it remains our position that service cannot be perfected through reservice. A proper service of the NTA vests jurisdiction with the court, and since service was not proper at the first hearing, the court did not have jurisdiction.
Counsel, we're past this issue. My hands are tied by a precedent decision, WASD, and we're moving forward. The government has corrected service. I have a notice to appear here dated January 12, 2017. 5 factual allegations and 1 charge. Are you waiving a formal reading?
Yes, Your Honor, but for the record, we still do not proceed properly.
Heard you, counsel. Service was proper. Your objection to my ruling is noted. Now, how do you plead?
We deny the 5 factual allegations and the sole charge of removability.
You're denying the allegation that the child was not a citizen? On what basis are you claiming that your client is a citizen?
Your Honor, I move the court issue sanctions against Respondent's attorney for unethically claiming the child is a U.S. citizen.
Hold on. I'm denying the allegations, and the government should be put to its proof on each of the allegations. We're allowed to deny the allegations without asserting that we have proof that the child is a U.S. citizen. The child is not required to concede anything at the stage of the hearing. You're holding the government to its word.
Well, I might be tempted, but I'm not going to enter sanctions against Respondent's counsel. Mr. Roché?
Your Honor, I have the 213 in front of me, and it states the child turned over her Honduran birth certificate upon encounter with CBP.
Respondent, now on what grounds are you denying alienage?
Your Honor, we've never received a copy of the I-213 or seen one on birth certificate, so I would request an opportunity to review the I-213 as I have some serious concerns about its reliability.
Well, Mr. Roché showed me the I-213 earlier today, counsel. I don't know how you could possibly raise an objection. If you haven't seen it, what's your basis for saying it isn't reliable?
From my conversations with my client about how she was treated at her apprehension, I have some concerns about her information.
Mr. Roché, do you have a copy of the I-213?
I do, Your Honor.
Counsel. So, counsel, I need to move this case along. I'm going to give you 30 days to review the I-213 with your client and file any motions that you'd like to file.
Thank you. Could you also set a deadline for any and all materials that the government wishes to submit to prove alienage? And we've also still not received that I-770 if one exists in this case. So if you could ask the government again to provide that I-770.
Good point. Mr. Roché, you have 15 days to come up with all the evidence on alienage, including but not limited to the birth certificate, and provide the I-770 to respondent within 10 days. I'd also like to see a copy of that because I don't know what it is. And counsel, you have 15 days after the government's submission to file what you want. And then counsel, you'll have another 15 days to file any opposition to whatever government respondent's attorney files. What forms of relief is the respondent eligible for?
Your Honor, the relief is termination. Any other forms of relief are not legally relevant at this point because the initial finding of removability has not yet been made.
Counsel, you would better be prepared to articulate relief at the next master calendar hearing. You're also denying this fifth allegation as to public charge. Can we address that issue now? What are the grounds?
The government also has the burden to prove that an individual is likely to become a public charge, and that's not the case here.
Your Honor, this child's an unaccompanied minor residing with her undocumented mother. Neither of them speak English. How are they going to support themselves?
That's irrelevant, Your Honor. The government must take into account the totality of the circumstances when deeming someone likely to be a public charge. Matter of 19 INA, Sec. 867, 1988, found that an unemployed woman who is young and who has no physical or mental impediments that would likely affect her ability to earn a living is not a public charge.
Counsel?
Fine, Your Honor. We'll strike the public charge.
So allegation 5 is stricken. Anything else from either party?
No.
No, Your Honor. Thank you.
Again.
So something came up that Helen wasn't expecting, which was that I had seen the I-213. Mr. Roché had given it to me earlier, i.e. ex parte communication. So that was a dirty trick on him. But I threw it in there because these things happen. You're going along, you think everything is normal, and then you overhear some remarks or you see some behavior that's concerning, that there may have been ex parte communication. Ex parte communications can happen. The judge is supposed to immediately go on the record and say, there was an ex parte communication, this is what it is, and to correct it if possible. And if not possible, then to recuse himself. So just be paying attention and respond. She should have said, what do you mean, Your Honor? When did Mr. Roché give the court a document that he hasn't given me? Did you discuss the case? I mean, that's likely to infuriate the judge as well. But it's good to get that on the record if something happens. So,
any questions on why we did
So this is the part that I didn't really get. I just read through in my PowerPoint slide, but typically kind of the procedural part of filing a motion to suppress or motion to terminate is finally denying the charges, or the allegations and the charges, and then hopefully getting a briefing schedule from the judge. When the issue comes down, when alienage is one of the things that you're contesting, I have found that it's helpful to ask the judge to set a deadline for DHS to submit any and all evidence, because I've had experiences where I've briefed suppression of one thing, and 2 months later, DHS files another piece of alienage evidence. And so it frustrates the court because it's like they're filing one piece and then you're filing a motion to suppress, and it's not very efficient. So asking the government to set a deadline, the judge to set a deadline for the government to submit any evidence they have all at once, so that you can create a brief that responds to everything at once, more efficient, and then the government can file whatever opposition they have to it. And I think you should, again, like if the government doesn't comply with those deadlines, I think you should move again to terminate because they failed to comply with the practice manual or the judge's deadlines they set.
I mean, I think it's important to note that in a motion to suppress, whatever information you put in, you have to support it with affidavit, other evidence, but the judge is not supposed to consider any of that on the issue later for removability. So, in other words, your client is going to be putting everything in that affidavit about what went wrong and why the I-213 should be suppressed, or other evidence should be suppressed, the statement that was taken under coercion. They're going to be saying a lot of the same things that they said or didn't say, but the judge is not supposed to use that subsequently to determine removability. I think, it's important to understand with the I-213s that, again, the system is sort of set up to go through quickly. They're deemed to be inherently reliable, but that's a presumption. It's not a factual finding. So if there's anything wrong, it's very important to bring those to the court's attention. You want to get everything on the record. So in writing is better than verbally, because if you're just verbally stating your motion to suppress or verbally arguing that something should be excluded, which can be done orally, it doesn't have to be done in writing. You may not be given the chance to get all your arguments out there before the judge issues a ruling, or you may forget something. So it's good to put these types of motions to exclude or motions to suppress in writing to the court. I have seen crazy things on an I-213, triple, quadruple hearsay, where you get down to the nugget of it. Somebody admitted, that somebody had committed some crime. Then, even though the person who gives that statement to the ICE officer is a police officer, they're still hearing it third hand. So it's maybe quadruple hearsay and it's just unreliable. And that might come up in a bond hearing, for example, as opposed to removability, or it might come up on discretionary release. The I-213s are also used to have made a prior inconsistent statement. So if there's anything wrong with them, get that on the record, because it can be used later to weaken it as evidence that the government might put in for other reasons. I've seen it say, like, a 3-year-old told immigration that they were coming here for a better life, and they wanted to work for 3 years and then return to their country. And judges have accepted these. It shouldn't be happening. Argue this stuff. Also bring to the court's attention if there were, these oppressive conditions that the kid was held in. Even if the judge is going to rule against you, get it on the record what this kid went through. Because later on, that could be used for any number of substances. The government needs to be, the trial attorneys may not know what happened. They probably don't know what happened. So you're the only attorney in the room who knows anything about what really went on in this kid's life. So you should get it on the record.
Do you think that any of that, like from your IJ perspective, is there any part where you're learning things that you would have never, like having Respondent counsel bring up some of these issues and bringing to light things that from an IJ perspective, not from a Respondent side perspective, you would have never known were happening?
Well, right. I mean, so IJs, when I went on the bench, I'd been practicing law for 11 years. I had been representing people, and initially I was uncomfortable because I was making decisions in cases that I knew very, very little about people, maybe 10% of what I had known when I was their attorney. But I was very familiar with the process. How did this case come to court? There must have been certain prior proceedings. Sometimes the government attorneys aren't even aware of all the applications that have previously been filed. They keep their court documents on the right side of their file and their prior submissions on the left side of the file, things from CIS, encounters with CBP. All of these documents are on the left side of their file, and sometimes they'll come to court and the file will be this thick, and they don't know what's in there because they haven't had time to review it. But you might know. And some judges come from federal government, come from being a trial attorney. Some of them come from other government positions that don't have any experience with immigration, and sometimes they're have worked as respondent counsels, and so judges don't know what to look for sometimes. They don't know what an I-213 is. They don't know who's, because the regulations specify, and it became very broad, who can actually authorize issuance of an order to show cause, a notice to appear. But it has to, before it goes to court, you vet it. And you want to see the signatures on that notice to appear, because sometimes there are changes made between the time somebody's apprehended and when it gets filed with the court. And, judges don't see this. They don't know anything about what's happened frequently. They just have the notice to appear, proof of service, the bond document, and that's frequently all they have in the file. So FOIAs are very, very important. for that reason. Because if you get your FOIA before you go to court, you'll be able to point out if there are errors. You can also talk to the trial attorney if you can get a hold of them before the hearing, and they will sometimes agree to give you copies of what they have to help speed things up. And especially if you're one of those attorneys who like to object in court, you haven't seen it, and you can, use that later to try to get them to give you stuff before you go to court. So what is it? The 10 task force free or? Okay. Yeah. I think I'll just go ahead and do that. Yeah. Okay. So, basically I prepared some remarks, and these are more from, I left the bench a little bit under 2 years ago. January 31st will be 2 years. And I was a judge for slightly more than 20 years. So I worked in this cocoon. I like to say basically I came out institutionally retarded because, you have people serving you. You don't have to worry about your workload. Where's it going to come from? You do have to worry about getting decisions out and handling the cases, but you're kind of coddled. And judges frequently don't know all of the stress that the attorneys who are representing people are under. I feel like there's a lack of, when a judge will say, I want your pleadings in writing, or file your motions at a different time schedule than what's in the practice manual. It's very hard for attorneys to remember this judge likes things filed this way, this judge likes things filed that way. And it puts a lot of pressure on practitioners, but individual judges aren't necessarily aware of what that's like. So I'm just going to speak from my perspective as a judge. And again, I was a little different than a lot of immigration judges. People, generally speaking, didn't always agree with the rulings I made or my analysis, but, so I'm not saying my views are what all the judges that you're appearing in front of views will be. The first frustration is really the work schedule. Judges are scheduled to be on the bench 7 or more hours a day, and this does not allow adequate time for them to do research, to read the files, to develop their own personal standards on how they're going to apply the law in particular situations. And this then encourages reliance on law clerks, who are usually, by the way, really terrific, but also reliance on boilerplate or more shallow interpretation of case law. The docket itself is grueling. Everybody's read these articles. I'm not saying it's harder work than what attorneys experience. I don't think it's even comparable. But having so many cases on a master calendar that you cannot adequately review each case and determine what the next steps in that case should be, that's why judges lose their temper when you raise the issue of, I'm not going to concede service of the NTA, or I want you to read these charges on the record. So the pressures of the job can cause impatience and the views that attorneys are trying to milk the system. So when you're going to raise these issues and ask the judges to go through step by step what they're supposed to be doing all along, you want to make sure you're able to articulate what your reason for doing that is. It's the government's burden, Your Honor. It's not my client's burden. Because almost all of the case is your client's burden, so when it isn't, use that. Pressures from the agency to complete cases in a timely manner, not to cause embarrassment to the agency by rulings that are overturned. Fears in some areas. I was last in the Seventh Circuit, where some of the federal court judges really like to slam immigration judges, and then you're kind of out there as an individual at risk within the agency. The pressures to rush through the docket can result in, more rapid decisions, oral decisions when actually a written decision should be issued, an oral decision right at the close of the hearing without even taking a break, and a rush to judgment sometimes on difficult issues. The fact is that there are changing priorities Immigration judges generally are kind of controlling of their docket. They like to think that they have control. But when, the agency or the executive branch of government makes decisions on priority of things change, that can become very frustrating. So these pressures can cause judges, to step back from having a real vested interest in legal issues or the idea that maybe they should create law, and sometimes even from interpreting and applying case law carefully. So again, there can be a rush to judgment. As far as attorneys' behavior that's frustrating to judges, coming into court with a very poorly worded argument, disorganized evidentiary submissions, untimely requests, poorly prepared witnesses, inaccurate arguments based on improper interpretations of case law. These all contribute to the judge's frustration, and although, most people who really spend a lot of time practicing immigration law don't do those things, many attorneys do. So by the end of the day, the judge can be exhausted from, all the sloppiness that they've had to deal with. Sometimes the clerks haven't given the judge a motion ahead of time. So sometimes evidentiary submissions haven't made their way to the file, so if the judge reviews the file before going to court, and as soon as they counsel, I gave you a 10-day follow-up, why didn't you file your documents? Your Honor, I filed it a month ago. It's not in the judge's file. So, the fundamental role of an immigration judge is to ensure that the hearing itself is full and fair, to make sure that all evidence which is relevant, fair, and probative is admitted and fairly considered, to ensure that the manner in which the hearing is conducted elicits full and clear testimony and is fair to the parties, to ensure that everything is clear on the record, the evidence, the testimony, arguments of the counsel, and their own rulings. They're supposed to be analyzing correctly and to apply the law fairly. And their decisions should be rendered in a professional manner. Some judges think they're dictating an oral decision and put in all of the dictation, where the new paragraph goes, where the comma goes, or period, and that's, dictating an oral decision, not rendering an oral decision. But if judges don't do that frequently, when their decisions get written up, it's very garbled. The quality has improved, I should say, in recent years. So the decision should include a statement of the case, a statement of the issues, standards of law, findings of fact, and then their conclusion. Frequently, they don't do any of those things because they're so rushed. But your role as the attorney should be to make it easy for the judge to grant your case and difficult to deny. And if you know that the judge is going to deny the case, to make sure that you have gotten everything in that you need to get in, so you'll have a way to argue your issues on appeal. You're the client's ally in court, but you're also an officer of the court and a member of the bar. So, your opposing counsel is actually supposed to be also, a member of the same profession. So everybody's goal in the courtroom should be the same thing, to ensure that the hearing is fair and that the just result is received. And there are trial attorneys who believe that. They're not coming into court to get everybody deported. You get trial attorneys who waive appeal on issues, who stipulate certain things, and you should try to encourage that to the extent you can. But justice can be very hard to find in immigration proceedings because the law itself is imprecise and an imperfect tool for resolving all of the issues that come before the court. And many immigration judges are just frustrated because they feel like they're being asked to resolve issues that they can't possibly resolve. The agency itself has fallen very far from its mission of providing full and fair hearings, and it's certainly not the best means through which a child can gain protection from all of the things that these kids have gone through. Immigration judges are subject to high expectations of professional conduct, but they have very imprecise and imperfect tools at their disposal. So again, by making a concise argument, a clear argument, even if it's a creative argument based on case law, based on international standards, if you make it clear to the judge what you're asking them to do, you can sometimes get them to think outside the box. So, you know, the culture of the court is kind of deteriorated, I would say. A lot of the senior judges are just incredibly frustrated. Some of them hope that the hearings will be streamlined, that the issues presented before them will be much simpler, that, you know, it will be easier for them to get final decisions out. I think it's very frustrating when you've gone through a hearing. Even I was a fairly liberal judge. I was sort of middle of the road, I would say. But, you know, if I denied somebody's cancellation case, for me to find out that the person is still in the U.S. 10 or 15 years later, I didn't mind that they were still here. But what bothered me was that if I had granted the case, that person would have been a permanent resident over those 10 or 15 years. So the impact of my decision was to basically create a second-class citizen, which wasn't the intent. If you're going to really be responsible in making these decisions to somebody to be sent out of the U.S., and if they never are, it kind of makes a mockery of what everybody's here to do. So there's a lot of those kinds of frustrations amongst immigration judges. So what helps a judge, an immigration judge, is for the attorneys to clearly define the issues, their arguments, the standards. Let the judge know if you've developed a novel theory of a case instead of citing case law as being dispositive of the issue. In that case, case law has nothing to do with your argument. If you're laying the groundwork for an appeal, say you know that the board is going to rule against you, and basically the judge's hands are tied because of that. And if you think the circuit court is going to rule in your favor, you know, put things in writing and just say, Judge, you know, we know how, you know, from other rulings that you've made how you're likely to rule, but we want to lay the groundwork for the appeal. And so doing that respectfully to the court is helpful. And then if the judge is hostile to some aspect of the proceedings, you know this in advance by doing the things that were on the slide that Helen put in earlier, observing hearings, talking to attorneys who appeared in front of a particular judge. Prepare your client for that so that the client understands it's not personal to them. It might be legally improper. It might even help their case at the end of the day. And that, you know, make sure that they're not thrown off course, that they lose track, you know, can't get through their testimony. So if the judge has particular pet peeves, you can also alert your client to that. Again, you know, your client has to speak the truth, and you have to promote speaking the truth in court, but some judges go off on tax returns, you know, failure to support their children, drunk driving. Your client has to be prepared to deal with that. So, you know, for the child, it's very difficult to prepare your child properly. I think getting other systems of support in place, if you have time and there are resources, counseling, the child might have to testify about things that happened to them. They're very traumatic. You can help prepare the child for that. Again, some attorneys for the government are fine with not cross-examining. Some go for broke every single case. So, you know, preparing the kid is really a key part of it. Again, just remember that the court, even though particular judges may employ this, the court culture is not to promote the best interest of the child. You know, they're not supposed to harm the child. They're supposed to conduct the hearing in a way that's friendly. But they're not allowed to say, you know, I'm going to grant this child release because it's in their best interest to remain in the United States. So, you know, I think strategies are to really develop a motions practice. Have boilerplate, updated case law ready. Again, Helen has given you some resources. They're really great. Steve Manning, who runs I can't remember, Law Lab. It's a place that people share briefs. And there are other, you know, people who've organized drop boxes for release and briefs and things like that. It's really good. Because at the end of the day, if you're getting a lot of cases and they're being rushed through the system, you're not going to have time to prepare all of your legal arguments, you know, from scratch each time. I just heard about an unaccompanied child who was granted asylum, and they're were living with their parents, and the parents both got picked up this morning. I think, besides preparing your clients for court, you want to help prepare kids and their families for what to do if this happens in terms of guardianship plans. So specific things that came out of the prior presentation. Again, make sure that the notice to appear that's been filed with the court is the same one that you have. The I-213s, there's this presumption that they're inherently reliable. They frequently are not in any way reliable. You can always argue in an individual circumstance that in this case the I-213 is not reliable. If you're seeking to suppress evidence, you really do want to highlight whatever things have gone wrong, regulations. If your client was picked up as part of a raid that was based on a warrant, if they didn't stick within the corners of the warrant, I'd be able to get evidence excluded and the case terminated for that reason. If your client was brutalized in some way, even if the judge is going to rule against you, get that on the record. People need to know. The 10th time a judge has heard the kid was, kept in this freezing place for 3 days, was threatened by older kids or gang members that were there, wasn't fed anything, wasn't given their rights, the judge might start believing it. The first 9 times, the judge might think you're just trying to get away with something. So remember that if you manage to get a document excluded, like an I-213, but there's other evidence of alienage, the evidence that was excluded can still be used to cross-examine your client. So just because it's excluded, you don't want to ignore the fact that it's in the record. You want to prepare your client to be challenged based on those statements. The question came up on if you're going to do a motion to change venue, are you going to plead to the charges or not plead to the charges? And I always looked at this as a judge. What's the underlying issue? So if the charge was somebody came in on a visa and overstayed, the government could produce that evidence very easily. But if the charge was somebody was stopped near the border, and there's a Border Patrol agent that might have to be called as a witness if you're going to challenge removability, then that's a case that maybe you shouldn't change venue until you know what the issues are. Some judges you've got to file the pleadings. Some judges say if you haven't actually admitted to the allegations, I'm not going to change venue on the case. And some judges want you to actually file your release before they'll change venue. So every judge is a little different on this. And the rules allow some variance there. Once allegations have been pled to, ordinarily you can't go back and withdraw those. A mistake of law, you can. But if it looked like it was a tactic to get a change of venue through, you're not going to be allowed to withdraw that later, unless you can show there was really something underlying wrong with it. The other thing is, and I don't know how many, I guess people here handling cases that are detained, and are the hearings by video or in person? Right. So many things. So I was the last 3.5 years doing detained cases in Chicago, and they were almost all initially by video. They moved the detained court where the judges were sitting to a place that they couldn't, with a civilian building, and they couldn't bring people in. And so to do the in-person merits hearings, I was the only one who insisted on that in almost every case, would go back to this old facility in Chicago and do the hearings in person. And the problem is, from the facilities, there were 5 different county facilities, and some places there was really no confidentiality. Other places there would be an officer standing nearby, maybe in a threatening manner and maybe not. But the judges who are hearing the case really don't know what those conditions are. So if there's any problematic conditions, and if the judge is hearing it by video, you want to bring those to the court's attention. If you're also in court with the judge, you may not know what's going on, but you can ask a few questions of your client. Is there anybody else in the room with you? Is the door closed? Can anybody hear you? Those kinds of questions to make sure that the hearings are safe and secure for that person. I would frequently at master calendar hearings, people would be able to say, yeah, I'm removable, I want to apply for asylum. But they couldn't say anything about what the basis of their asylum case was. If it was gang-related, there might be a gang member there. If it had to do with their gender, their orientation, they would put them at great risk. Any number of things can come up. So, pleading things in open court at a master calendar can be very difficult and harmful to people, especially when they're in custody. So those are my thoughts. I don't know how helpful it is or how similar it is for other people, but basically, judges do get very frustrated, so it isn't always about your case, at all. And I don't think it's okay for that to be happening, so I think you want to stick to your guns, but do it in a calm and rational and well thought out way. Sorry, yeah. Right. So you want to know, what are the issues? Is it appropriate to change them? Like I said, if the underlying issue is you're going to contest removability and there's a witness who the government might need to call to establish, that should happen at the local level. Now, sometimes that initial hearing is at a completely different location anyway. But some judges don't want to ask, they see it as a delay tactic, and they don't want to encourage that. So what they want you to do is, okay, not only should you have admitted and conceded, you should also have filed your application for release. But when this case goes to the next judge, it's ready to go. It's not going to start all over again 6 months down the line. And especially if you're changing venue from a hearing, a location where the judge is ready to go, and they know you're going to change venue to a location where there's a 2-year wait for the first master. This is just one of those delay tactics. And some judges just don't care about that, and some judges take it like you're, insulting your mother. So you got to know your judge. Yeah. Any other questions today? Yeah. I think, the judges feel probably that the 1-year continuance, which is due to the overcrowded docket, is an inherently unreasonable delay in the case. But they want to make sure that it's a legitimate case, and they want you to get your pleadings, not your pleadings, but the application in, so that judge can be sure that the case will be ready to go forward at the next hearing. I mean, I know there are judges who insist on things to make it more difficult, but I think that's more rare. I think they're just trying to impose some kind of order. I think if you need more time, you can file a motion to expand, the time for the release. And if you have a good reason, I think most judges would grant that, and if they didn't, and then wouldn't hear that release after you came back in a year, that would be a pretty good interlocutory appeal, or, once the case is completed, a pretty good appeal. So, some judges might be doing it to, in fact, yes, they want that child's case to have been already decided by the asylum office before the next hearing. I think that's likely to be happening. My understanding is they're moving asylum officers to the border to hear cases for people who are, maybe held in Mexico. So it's going to be, I think even the cases that have been a priority may get lesser priority. I don't know, but, the idea should be to not delay the case inordinately, but to, when the case does come back to court, that it's really moved forward and ready to go somewhere. And the judges are very frustrated over how long CIS is taking on certain applications. I don't know what the specific reason for this 60-day follow-up is. It could be, just arbitrary in some ways, but it could be, it seems like to the judge enough time to get the case ready to file. So just make sure you're getting the cases done. Yeah. Any other questions at all? Comments? Yeah. Right. Yeah. I mean, I think definitely in Article 1 court. I mean, I think the fact that the immigration courts are kind of at the tail end of immigration enforcement. They have been. I mean, their funding used to come directly from INS. It's kind of up to the district directors to decide how they wanted to treat the courts and the judges. And over time, it's become, became independent in '82. And, I think making it an Article I court would protect it from some of the political pressures. I mean, I will say in over 20 years of being an immigration judge, nobody ever tried to push me one way or the other on how to decide a case. So it's not political in that sense. But the pressures to get cases done, was really something. Instead of in the federal courts went to, priority cases and case completion goals as well, but that was based on what the courts felt was right. What happens with immigration court is that there's some arbitrary standard. No case should take longer than 6 months. No case can go longer than 5 years. So the immigration judges are, periodically told you've got to pull all your old cases in, and the cases that are just coming in, you push those out later, or those cases aren't a priority. You're going to hear all these asylum cases, or those asylum cases aren't a priority. And after a while, it's just very discouraging. And judges would be protected from that if it was an Article I court. There's, more professionalism. I have a lot of criticisms about the trainings that immigration judges have had. We didn't have in-person training for 5 years. And that's a chance to sort of talk to your colleagues around the country and figure out how people are handling things. There are these outlier courts that, the culture of that particular court might really be different than other courts. So it's really helpful to judges to meet each other from around the country and talk about what's happening and how they're deciding certain issues. And, I think being an Article I court, yes, would be far better. Yes. So, I mean, I actually granted, if you Google my name, and gang based asylum cases, I granted a Salvadoran asylum case, but it was a case where I think it was a brother that had been killed by a gang, really just because of gang violence, and he opposed that gang on some issue. And then at the funeral, the father made statements about he was going to make sure that whoever had done this to his son was going to pay the price. And then they started targeting all the family members. So it was really a family-based case. So if you're the relative of somebody who's been opposed to a gang or didn't do what the gang wanted and they're going after your family members, that's a family-based case. If you're a religious person who is working in the community to educate people against joining gangs, trying to promote other activities for youth so they don't get caught up in it, that can be, a political opinion or a religious-based case. I think that the gangs are very different than what the U.S. really sees them as. They're kind of mini governments, and so we see them as just bad people that are committing crimes, and unfortunately the U.S. doesn't provide protection from, even the victim of a crime. Or just they want to get money, or they want to force you to join them because they want more power. Those aren't considered, obviously. So you have to look for whatever's there. Is the family, do they have a particular position in the community? The gangs are targeting you as part of the family because they want to coerce everybody else in the town to go along with whatever they're insisting on. So there could be a social strata issue. A lot of the Central American cases, I think it's different now, but for a period of time there was this hatred of each other because of what had happened during the 80s. The people had been in the military previously, and you're the son of somebody who was in the military, maybe the person who was in the guerrilla, their son hates you because of that. So, there are some historical issues. There are some areas where, there's a lot of gang violence, but there's other things that have happened in the past that cause people to be targeted, and it's not obvious. social group membership, just so everybody knows, has always been the source of most of the litigation, because, respondents' attorneys are arguing it's very broad and inclusive, and the government's arguing, no, it's very, very narrow. You have to be visible socially. I mean, over time, it has been much more expansive. I mean, I started out practicing, we were talking about Central American asylum seekers, cheese makers, map makers, taxi cab drivers. They're being targeted for that reason. So you have to really know the history. Yeah. Anything else? Yeah. Oh, 2 people back to back. Yeah. Sorry. Yeah. Yeah, I mean, so there were certain trainings. We did have trainings every year, but they weren't in-person trainings. They just came, you get a CD and you sit at your desk for a week watching, very, very boring. But yes, there was always the vulnerable populations, unaccompanied children. There were trainings on basically how to run the court, so it's sort of friendly to children to get them to relax. Who are you? At some periods of time, some of the judges would not wear their robes, would not sit up on the bench, would sit at the table, and different things. But the same person, just so you know, who's responsible for immigration judge training is the same person who argued in Washington, case in a district court in Washington, that he was able to teach 3-year-olds immigration law. But I think he was sort of talking about the emotional intelligence of the immigration judges he's been teaching all those years. But he made this argument that, you can give a fair hearing to a 3-year-old unaccompanied child without an attorney, and it could be fair. And that, I just think is inherently ridiculous. I don't think he really meant he was teaching them immigration law. He just misspoke. But, that's what the agency promotes. Fight for these kids I swear, fight everything you can get. And I'm sorry, yeah. It would be oppressive conditions. Well, it depends on what you're arguing of them. If you're trying to suppress a document, like a statement, a sworn statement or something, first, go over it with your client, make sure that if they say was that said or wasn't it said. And then if you're trying to suppress it, you put in the child statement, you put in other reports of what's happened. I know there's compilation of horror stories that are coming out. There have been reporters that have gone undercover and gotten some photographs of some of these places, put all of that on. Also, the child, even before they get to the border, has probably gone through hell, and both in their country and en route. So try to find out what they've gone through and put that all on record. I mean, because the problem is that, the last president said that, the best thing we can do for these children is to return them as quickly as possible to their parents and their country. And, we don't know what the new president is going to be doing as far as these particular kids, but it's just kind of the system is just rigged against them. And you have particular judges who are handling these dockets who are trying to do what they can. But I saw a docket in New York, one judge master calendars per day, 170 cases. 170 cases in a day. And it's just, so do whatever you can to document your individual client, what they've gone through, and put it in a motion. I don't think you're going to want to put your kid on the stand and have them testify about everything, but, put as much of the evidence out there as you can, information for your client, but try to put it in a written form, because then nobody can ignore it. They can't make sure it doesn't get on the record. Yeah. Most of them do not. I mean, when I went to so September 2015, after I left the bench, I spent a week in Philly. And I went back to Chicago and was talking to one of my colleagues who handles the all get out with positive findings, but they were released. Most of them had, at some point, had a credible fear they were going to have a hearing. But I had a couple of people who had, orders of removal that they released anyway. And I said, what people have gone through from that time, up until that point was just outrageous. And she was very shocked. So, and actually to detain people for so long and then release them is even, if you're actually going to return people, it kind of sort of makes a little bit of sense. But if actually what you're going to do, even though you've detained people and made them miserable, is then release them, anyway into the U.S., it makes zero sense. It's actually very destructive. So, I think some judges do know, but I think most do not. Yeah. What's the best approach if the judge is running everything through the TA, that is relying too much on what the TA thinks should or should not be done? Every judge runs their court a little differently. If you believe that you're not being given the opportunity to be heard, you need to object to that. If you think the judge is not giving you the same consideration on something that they're giving the government's arguments, I think you probably have to appeal that. Try to make sure. One of the problems is that a lot of things that happen in the courtroom don't show up on the transcript, really. Tone of voice doesn't show up. Sometimes judges do things off the record and fail to go on the record and say what they've done. You should always say, I'd like the record to reflect what happened off the record. Facial expression, sometimes judges seem angry. I think some things a judge can be told and they can hear it and they can correct their behavior. Sometimes you just have to make sure the record reflects what's happening and take it up on appeal. And you have to kind of know what the difference is. If they're really not listening to any of the arguments and only listening to the government, and other attorneys are experiencing the same thing, you could try to see if you can complain about it, but then you have to make sure there's something that's on the record or is objectively findable. Yes. All right. Yeah, so we had talked about this on the lunch break, is that so the court now is bound to do full and complete translation. Attorneys can waive it, but what they have decided to do is to have everything be done simultaneous instead of consecutive. And I really preferred the consecutive translation for a number of reasons. One is that I'm not fluent in Spanish, but I was fairly fluent in courtroom language, so I could really understand what was being translated, and frequently there were mistakes. Things missed, things just mistranslated. Second thing is it gave everybody a sort of a breathing room in terms of thinking about what the next question should be. Is there going to be an objection to something? With the simultaneous, the headphones on, people are not able to hear what's actually being said, other than, the only thing that's going to show up on the transcript is what's in English. So if you are objecting to translations, you don't know how to do that during the hearing if you're not actually hearing the translation. The other issue is that the court interpreters are really not being treated correctly in terms of their workload, and if you do simultaneous, you're supposed to get a break every 25 minutes and get a substantial break. In federal court and in international, they have relay interpreters, which the immigration court does not do. So there's much that gets missed with the simultaneous, I'm afraid. I think it's much easier for the interpreters who are used to it. I don't actually know the answer to that. If it's full and complete, if you waive full and complete and ask for consecutive, what that means is that the arguments of the attorney are not interpreted. You can ask for the headphones to be on, but ask that the translation be consecutive, so that you can hear what your client is saying and compare it to the interpreter. I don't know what the judges are going to rule on that. I think they have some discretion, unless you show a pattern of mistakes by a particular interpreter. You probably can't insist. other questions? Yes. So I did not hear cases of the unaccompanied children, and I can't not speak to that. I can say it's far more difficult for an immigration judge to make sure that a hearing is really full and fair if there's not an attorney there. I did handle cases, people with Roché, even in the detained setting, even granted a couple. But, you know, the chance of people without an attorney winning their case is pretty slight. Sometimes that's because they don't know what's relevant and the judge doesn't ask all the questions that need to be asked. Sometimes it's that the cases really aren't that strong and they've already consulted with an attorney, and the attorneys have said, I can't really help you, you know, don't waste your money. But I cannot speak to the children in court without attorneys. I did not have experience with that. I'm assuming it's not good. You know. Anybody else? I don't know if there were questions for Helen or for Brandon, but you guys are very clear. People have any experiences they wanted to talk about or anything? Yeah. Well, no, I mean, I am interested to know what's sort of happening, you know, in other courts. I mean, I know a little bit about some courts, but I'm just curious. Are the judges generally good with the kids? They deport. The other thing that I think is really important is if you have a client and the client does get deported, try to find out what happens to them. One of the things as a judge that I didn't like was I never knew what happened to people if I ordered them removed. And the only time that I found out, I was complaining to a friend of mine who was a psychiatrist about, yeah, you know, I made this decision to send this young man back to Russia, and I don't really know if it was the right thing or not. And I felt bad because his older sister came and testified for him. She was really wonderful. And my friend goes, did the older sister, you know, work in this kind of a field? And I said, yeah. She said, oh, she's my patient. And then she said, you know, he's doing great. He's living in Moscow with his aunt, who's really got him under her wing, and you know, is making sure he's kind of stays to the straight and narrow. And you know, my patient is much happier because she's no longer worrying about the trouble that her brother was getting into. So like, yeah, that was the only, you know, at least I found out in one case out of, you know. But if you, you know, try to, you know, keep track of the kids that are sent there, what happened to them, because, I mean, I suspect it's horrible, right? But, you know, I think people need to know. I think there are some judges who think these kids are just coming to economic reasons, you know, to this day. I don't know that, but I suspect it. Right. 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 It is easier psychologically to think somebody's lying than to believe that they're telling the truth and still send them back. And, you know, some people take the easy way out on that. It's easier, you know, it's hard to listen. One of the things that an immigration judge has to listen to these tales of torture, horror, and they get secondary trauma from that. But in addition, you have to listen to this in this kind of weird way of trying to figure out if what they're saying is true or not. And, you know, there are a lot of people who make up stories. Maybe they should be allowed to say anyway on a moral level. But there are people who lie. I'm not saying the kids are among those people, but, you know, it's not an easy job to sit in judgment of somebody who comes from a country where these horrible things happen. It's very difficult to believe that somebody's telling you. It's hard cognitively to, you know, keep unified in your own mind and heart to believe that somebody's telling you this my role here is to decide if, you're going to be harmed for one of these 5 reasons, and you're going to be harmed, but it's not for one of these 5 reasons, I'm going to send you back. Because that's what the law requires. It's very hard to do that. So it's easy for people to think the kids are lying. I think it's getting harder to do that because of more of the publicity and what's on TV and the news that's out there. Yeah. So first of all, I think it would be really wrong for a judge to be worried about getting appealed. I think there are judges who do, but it's not a factor. It shouldn't be a factor in the decision. The asylum laws, I sort of believe, are a little fluid. You have to go with not just your perception of what was the intent, but what are the country conditions like, and what's the history? What are the patterns of the way people treat each other? So, one thing is that people are frequently really horrible at getting into the mind of a gang member to say, why is this person threatening to kill me? And that's what you kind of have to get to what's the motivation. If the parties have argued something that's just not tenable, you can't make a finding that they've on that basis established eligibility, but you can, as a judge, say, but you haven't discussed these other factors, and I think there might be more to this particular situation. You can make a finding based on the country conditions. If somebody's indigenous, if somebody's, linked in some way to some historical event. But yeah, you sometimes have to. I did deny release to people who I thought were at risk of some harm, but I said it was not persecution, or it wasn't severe enough to be persecution. I did make some of those decisions. Yeah. That's what the appeal process is supposed to, Do I think that makes a difference? And it can. Oh, so the question is based on, what kind of evidence have they obtained? If they've gotten the complaint from the police. Yeah, but sometimes those are just paid for documents too. If a lot of times people cannot get evidence, even to try to get the evidence would put their family members at risk. Sometimes the evidence doesn't exist. I didn't file a report because if I did, the police were, linked to the gang, would just tell the gang, and then it would be worse for me. That's credible in my mind. I know some judges don't think that is, but I think it is. But then you can't say, but I'm a witness who made a report, and because I made the report. I will say this about the children's cases. Many years ago, I had a case that I argued at the board that when you're dealing with children who are asylum seekers, you need to apply a different standard of what types of evidence would they have to show they're at risk, because they wouldn't have had the same interactions with authority figures. They wouldn't have had, the experiences that an adult would be expected, especially if it was like political opinion or religion. And this was, again, it was Central American kids that were anti-government, El Salvador, but they hadn't had the opportunity to speak their views, but they had the views. And, the board never issued a decision on it. I looked at international standards, the UNHCR handbook, which says clearly that children should be held to a different standard. And one of the problems is they're not held to a different standard. They're expected to bring a letter from the persecutor. Oh, you're welcome.
Your Honor,
Thank you. And,
thank you for coming in from Chicago, and thank you, Helen, for coming in from California. We appreciate both your perspectives here.
Yeah, and thank you, everybody, for all your work. I know it's heartbreaking.
We're going to take 10 minutes before we come back with Selena Moreno from Malda.